In Australia, citizenship once meant certainty. But since 1986, Parliament quietly redrew the boundaries. It first ended automatic birthright, and then it empowered revocation in the name of national security. Fast forward to today. Record migration, tighter visa controls, and more than 300,000 temporary arrivals in a single year have created a vast group whose status feels anything but secure. With talk of a looming 2026 crackdown and claims that 2.1 million people could be swept up, the stakes for belonging have never been higher. Yet the real story behind who is truly at risk and how citizenship itself became so conditional remains hidden in plain sight. How did the rules of Australian identity shift so dramatically? And what comes next for those now living in the shadow of the system? On the 20th of August 1986, Parliament drew a new line through the idea of belonging. From that day, birth on Australian soil no longer guaranteed citizenship. Now at least one parent had to be an Australian citizen or permanent resident. The old certainty, citizenship by birthplace, gave way to a system built on conditions and exclusions. The Australian Citizenship Act 2007 cemented these changes. Its rules spelled out who could belong and who would wait, 4 years of lawful residence, at least 1 year as a permanent resident, and strict limits on time spent overseas. For many students, temporary workers, refugees, years in Australia did not always count. The path to citizenship narrowed, and the promise of belonging became conditional, not automatic. By the mid-2010s, security concerns reshaped the debate. The 2015 Allegiance to Australia Act gave ministers the power to revoke citizenship from dual nationals convicted of terrorism-related offences. The message was clear: those who broke faith with the nation could be cast out. Critics warned about unchecked executive power and the risk of statelessness, but the law held. Ministerial discretion became central to the system, and the boundaries of citizenship grew more fragile. The High Court intervened in cases like Love versus Commonwealth and Toms versus Commonwealth, ruling that Aboriginal Australians could not be classified as aliens under the Constitution, regardless of birthplace or paperwork. Yet these decisions left large areas undefined. The court set limits on the most sweeping uses of ministerial power, but left open many questions about exclusion and discretion. By 2023, Parliament shifted citizenship revocation from ministerial decree to court order. Now, only a court can strip citizenship, and only for dual nationals convicted of serious offences, with safeguards against statelessness. Still, the executive decides when to seek such orders, and the meaning of repudiation of allegiance remains contested. Over 4 decades, the legal structure of citizenship in Australia has shifted from certainty to contingency. Each reform has layered new conditions onto the right to belong, making the boundaries of citizenship both sharper and more precarious. Australia's migration intake today is shaped by a complex web of policies and numbers. In the 2024 to 2025 year, net overseas migration stands at around 306,000 people, with total migrant arrivals reaching 568,000. Out of these, about 363,000 are temporary visa holders, students, skilled workers, bridging visa applicants living in Australia without the certainty of citizenship. The number of first-time asylum applicants has also climbed, with 33,000 claims lodged in 2023, a 69% jump from the previous year. Each figure represents a person whose right to remain is subject to ongoing review, new requirements, or the outcome of a pending application. Policy changes have tightened the system further. The latest student visa integrity measures demand higher English test scores, stricter financial proof, and greater scrutiny of applications flagged for possible fraud. Repeat student visa stays face new restrictions, and visa charges have increased. These steps are part of a broader agenda to address what officials call systemic risk in migration flows. Home Affairs analysts now rely on risk rating frameworks to assess both education providers and source countries, drawing on data such as visa refusals, protection claims, and compliance breaches. While these tools aim to protect the integrity of the program, they can also shift quickly, leaving entire cohorts exposed if the data changes. This landscape has created a large pool of people whose status is conditional, a group that now numbers over 2 million. Some are long-term residents who have not yet qualified for citizenship. Others are temporary migrants caught between shifting rules and uncertain pathways. For many, the line between belonging and exclusion is defined by administrative decisions and algorithmic scores, not just the passage of time or community ties. The pressure to manage risk at scale is visible in the numbers, but the lived reality is a growing sense of precarity for those who call Australia home, but remain outside the circle of citizenship. Inside a nondescript government building, a small analytics unit manages the engine behind Australia's new citizenship risk regime. The system is called CITRISK 3.0. It began as an evidence-level framework designed to flag education providers and source countries for visa fraud or compliance breaches. Now the algorithm's reach extends far beyond universities. Every data point, from an address change to a travel pattern or a flagged social media post, feeds into a composite score. This score can tip a person from routine review to status at risk overnight. A leaked internal memo from early 2026 describes the system's evolution. It reveals that CITRISK 3.0 moved from static rules to speculative analytics, layering in third-party data and machine learning predictions. The memo warns of a high rate of false positives, people flagged for risk based on associations or outlier behavior rather than clear evidence. One anonymous data engineer describes the challenge. We are combining old visa refusal data with new behavioral inputs. Sometimes the model jumps at shadows. The scoring process is opaque. Each individual's profile is broken into risk factors: prior visa refusals, changes in declared employment, unexplained absences, or even connections to flagged community groups. The algorithm weighs these elements against shifting benchmarks. A sudden uptick in protection visa claims from a particular region, for example, can raise scores for thousands overnight. The system's designers intended it as a tool for efficiency. But as the memo notes, small errors or outdated data can trigger life-changing consequences: loss of work rights, Medicare, or even the initiation of court-based citizenship cessation. Critics inside and outside government warn that the predictive logic of CITRISK 3.0 is poorly calibrated for the complexity of real lives. The system's defenders argue it is necessary to manage scale and protect against fraud. The leaked memo's conclusion is blunt. Composite risk is only as reliable as its inputs. When status hangs on a score, mistakes are not just technical, they are human. An independent audit released in February 2026 cut through the advocacy slogans and political spin. The headline number, 2.1 million Australians at risk, collapsed under scrutiny. Analysts traced its origins to a 2023 campaign graphic, not official records. The audit's own tally identified about 80,000 people in genuinely precarious legal positions: long-term bridging visa holders, people with unresolved protection claims, and those with negative character decisions awaiting removal. For this group, the risk is not theoretical. Their status can change overnight, often with little warning or recourse. Legal scholars challenge the wider use of the status risk label. Professor Alice Zhang, a constitutional law expert, points to the dangers of inflated figures. She says when advocacy outpaces evidence, it distorts the debate and undermines targeted reform. She argues that the evidence-level framework is past its sell by date, that it produces perverse incentives and leaves too many people in limbo. Her analysis finds that the system's complexity and shifting benchmarks trap people in uncertainty, but she warns against folding millions into a single risk category. A former Home Affairs advisor defends the government's approach. He insists that risk analytics are essential for managing scale, especially with over 300,000 annual arrivals and a backlog of unresolved cases. He says without predictive tools, the system buckles, and we cannot afford to ignore fraud or compliance failures. The government spokesperson echoes this, stating that integrity measures and CIT risk 3.0 ensure that resources go to those who meet the rules and pose no threat to the community. 3 scenarios now shape the policy horizon. In the first, the crackdown continues, and the susceptible cohort, those 80,000, face rapid status loss and removal. In the second, judicial review and advocacy force a recalibration, narrowing the net but leaving algorithmic scoring intact. In the third, a High Court challenge forces Parliament to rethink the balance between security and citizenship, opening the door to new protections but also new uncertainties. Each path carries its own costs for individuals, for the rule of law, and for the meaning of belonging in Australia. Citizenship is now a conditional status for millions, shaped by shifting laws and invisible algorithms. As digital systems judge who belongs, the line between security and exclusion blurs. In a democracy, rights are only as secure as the rules that define them. The question is, who decides?